Objection, Your Honor. So I don't get a hearing.
She's been in court with all of her children, 2 of whom are parental
So
rights.
I have a full-time job. I wasn't able to file those objections in a timely manner.
Allison, you could mute
In
her,
today's
please.
case, a mother fights a custody ruling that gives the father more time than she's willing to accept. Her objection put the transfer on hold, and now she's scrambling to introduce new evidence. The judge must decide, does she get another shot, or is this battle already lost? Buckle up. This one's a courtroom disaster.
2319387-DS. If I could have your appearance on the record, Mr. Blumberg.
Thank you, Your Honor. Elliot Blumberg on behalf of Mr. Fennell, who's appearing via Zoom from my office. Judge, this is our motion to strike the plaintiff's objection to the front of the court's recommendation dated January 22nd of 2025. I don't know that you've had an opportunity to review the motion itself.
I have.
Okay, well, then, you know, the 46th Circuit Court has been pretty strict in terms of filing objections and making specific findings or objections to the findings made by the referee. And generally, only those matters get heard on de novo review. Ms. Crow, on the 21st day of the objection period, hand wrote and filed an objection that didn't address any of the findings made by referee legal, but rather attempted to explain her situation. I don't even know if she's present here today. She has not filed a response to my motion. We would respectfully ask the court to dismiss the objection.
All right. I do see Ms. Crow here present today, so I'm going to give her an opportunity to explain what it is that she is objecting to. Ms. Crow, this is your opportunity. Please go ahead.
Your Honor, I have had my son for the last 3 years, since the day that we got him back from CPS. His dad went into jail February 21st of 2023 for aggravated assault on a 17-year-old, which I gained full custody of my child at that moment. He got out in December. The reason why the judge was going to give Jason custody is because I live with my parents and the situation is volatile. During the period from the ejection, the reason why it took so long to file is because I worked 56 hours a week at Wendy's. Since court, I have acquired 3 more jobs. I start at Burger King orientation on Monday. I start orientation for KFC on Wednesday, and then Jimmy John's wants to start me on Friday. I'm just trying to see which job has the best hours and better pay. I have $2,000 coming for my own place when my taxes hit. They've been accepted. I'm just waiting for them to hit within the week or two. And I'm getting $2,100. I am getting a car and my own place as soon as those taxes hit. I've already talked to Tom Serino. My son is doing amazing in school. He is for kindergarten that is sitting at a 1st grade level. He has severe separation anxiety. It's to the point where on days that he comes back from his dad's, he's really clingy. He whines and cries a lot on those days. Days that he goes to his dad's, he's a little apprehensive in the mornings. It's hard to get him up. But I don't mind having 50-50 custody with his father. It's just the fact that I've had him for the last 3 years, and they're trying to take him from me completely and give him directly to his father. I have been his only constant. And the fact that his dad got out of jail for aggravated assault on a minor, that's very concerning.
All right. I appreciate all of that information. However, here's the problem that I have, and it's what Mr. Blumberg has stated in his objection, or in his motion to strike, which is, I need to know which or what you object to, not the facts of what you want to add to that. But I need to know what parts of the referee's decision do you disagree with specifically? So you've told me all of the information that you have, but you've not told me where that goes.
Okay, so I object to the fact of me getting every other weekend with my child after having him for 3 years. And I object to Jason getting full custody. I believe that it should be 50-50. Me
All
and
right, go ahead, finish your thoughts.
me and Jason have been communicating through a parenting app close that was court ordered. I talked to Shasta Crouch yesterday about possibly filing either a PPO or harassment charges, because even on the close app, he is very derogatory and rude and mean, to the point where it's not even about the child anymore. It's about past
Okay.
grudges.
Ms. Crowe, you're once again veering off from the question that I asked. So you object to the full custody decision, and the other objection that you had was what again?
To me only getting my child every other weekend after having him for 3 years.
All right, what you are objecting to is the end decision, the conclusion that the referee made. The referee made that conclusion based on a number of factors that he had to determine, which are called the best interests of the child factors. There's 9 or 10 or 11 of them, depending on how you view the statute. Which of those did you disagree with?
Well, considering my son has been with me, I wasn't able to speak on the bond with my child, because I'm autistic and I'm representing myself. I didn't know that I could ask for a court-appointed attorney on a custody case. I didn't know that I could ask for time to acquire an attorney on my own. I haven't had custody of a child before, and this is new to me. But the fact that I am fighting for my child on my own should say something, for one. For two, the recommendations that I am disagreeing on is, during the time of custody with me, there has been numerous issues with Jason himself. There was a court recommendation where he is not allowed to drink around my child, and he violated that court order, where he was stated drinking.
All right,
It just,
ma'am, slow down just a minute. You're getting back into things that, and I know that this is hard for you. I appreciate that, and that's part of the problem with trying to represent yourself, is you don't know what the law asks you to do. So you just want to tell me everything. And I do appreciate that. And I'm being very careful trying to listen to what you tell me. But this is a fairly narrow area of what we're asking, what can be done. The referee had a hearing at which you could have brought up all of the things that you're talking about today. What were you?
to, Your Honor.
I'm not saying I'm not saying you didn't. I'm just saying you had that opportunity. The question isn't, do you agree with the ultimate outcome? The question is, did you have an opportunity to tell the referee all of the same things that you're telling me right now? And it seems to me that you did. Is that true? That you had an opportunity? Not did the referee agree with you, but did you have the opportunity to say all those things already?
Sort of yes, sort of no. When the first case started, it automatically went in to Mr. Bloomberg and him calling witnesses and me having to combat those witnesses. Nobody asked about my bond with the child. Everything that I say that my child tells me or tells counselors or the school, because it's not documented by a counselor, they say it's hearsay. So I could tell you till I'm blue in the face my child is scared to go to his father and he doesn't want to go, but the judge will sit there and tell me it's hearsay. But yet, when the child goes to a counselor and the child sits here and tells me to my face that she's lying, that he doesn't believe me. It's not what's in the best interest of the child anymore.
All right, Ms. Crowe, I can't change the rules of evidence. They are what they are. And whether or not you can get certain pieces of information in front of the judge or in front of the referee depends on the rules of evidence. So I can't change that. I can't listen to anything different than what the referee could. I couldn't change how that comes in or doesn't come in. So
I understand.
what you're asking me to do is to change the referee's decision because you're upset that the law doesn't allow you to get certain pieces of information in, and I can't do that. The question I have today is, what specifically do you want to object to? And you've told me the full custody decision and the every other weekend decision. And then I've asked, what evidence did you not have the opportunity to present?
Oh, since court, I have been able to, my taxes have been accepted since court. I wasn't able to tell them I have $2,000 saved in an account as soon as my taxes hit for a place. I wasn't able to tell them, get my bank statements to show them, how much money that I'm making at my jobs or my, schedule. And at that time, I wasn't able to state on my bond with the child because I was confused on to the questions they were asking.
When was the hearing that you had with the referee was in January 22nd of this year, right?
Yes, sir. I did
When
not get my W-2s until the end of January.
All right, but you would have had an opportunity to tell the referee that you were going to file your taxes and that you were going to use the refund that you received there for housing and transportation purposes, right?
Yes, sir. At that time, I did not. That was my mistake.
And the bond that you had with your child, I assume that you told the referee that you loved your child, right?
Yes, sir. I told him that that child is my whole life. I can't imagine not waking up to that child and getting him up for school every morning. Like, that's my routine. He's my sole purpose. That's why I work so many hours, to try to get us out of here.
All right. Let me ask one final question then. What, if any, other additional live witnesses or new evidence would you have to present at a hearing in front of me?
My cousin, the foster parent, who was the foster parent to my child while he was in foster care, would like to speak on my behalf. I have a school counselor that said she would like to speak on my behalf. And I have a few other people who would like to speak.
And why were those people, the foster parent and the school counselor, why were they not used at the referee hearing?
Because the foster parent, she was downstate dealing with a surgery with her child. And the school counselor, I wasn't able to get a subpoena to because I don't know exactly how to go about getting subpoenas. I'm seeking counsel through Michigan Legal Help.
Your Honor, each of us had ample opportunity to present all the witnesses that we needed to. The child's counselor testified at the referee hearing. Ms. Crow testified at length at the hearing. Again, the fact is that she doesn't and has not made specific objections, and the court has inquired of her, what is she objecting to? And all she can say is she doesn't like the result of the hearing. That's not a basis for a de novo hearing, Judge. I appreciate and again, this isn't the first time she's been in court. She's been in court with all of her children, two of whom her parental rights were taken from, one of which she has no parenting time with. So she is familiar with the court process. She continues to represent herself, and this is the outcome. And so we're asking the court to follow the law as it relates to the court rule and her obligation to file specific objections to the referee's findings, which clearly she has not done.
Objection, Your Honor. So I don't get a hearing because I don't know the specific laws of the court because I'm not a lawyer. That's literally what he's saying. I don't know how to file a subpoena, so I wasn't able to send subpoenas to my witnesses. I was working 56 hours a week, so I wasn't able to file the objection on a timely manner because I'm working. As of my son's father only gets disability. So
Okay,
I have
Ms.
a
Crowe?
full-time job. I wasn't able to file those objections on a timely manner. I represent myself.
Ms. Crowe, are you done now? So I
Yes,
can
sir.
speak? Thank you. You are required, like everybody else is, to know what the law is. There is no lesser amount of knowledge that you get accredited to you simply because you do not take advantage of what the law says that you can. If you represent yourself, you take on the responsibilities of knowing what the law is. It's like driving. You have to know the laws of the road in order to drive, and everyone that drives is assumed to know those laws and is responsible to know those laws. This is no different than that. When you come into court on a child custody, parenting time, or support matter, you are required to know the rules and to follow the rules, just like I am, just like Mr. Blumberg is. Now, I get it that you may have an actual lesser ability because you've not been to law school, you've not been a practicing attorney. I understand all of that, but you're still required. So here are the rules that I have to play by. In order for you to ask for what's called a judicial hearing or a de novo, that is a hearing in front of the judge, the court rule says, to the extent allowed by law, the court may conduct a judicial hearing by review of the referee's the record of the referee hearing. The court must allow the parties to present live testimony at the judicial hearing. However, the court may, in its discretion, prohibit the party from presenting evidence on findings of facts to which no objection was filed. So anything that you didn't specifically object to, that's why Mr. Blumberg asked what you were objecting to, I don't have to give you a chance to have a hearing. Determine that the referee's finding was conclusive as to a fact to which no objection was filed. So if you don't object, that fact is presumed to be proper. And then finally, prohibit a party from introducing new evidence or calling new witnesses unless there is an adequate showing that the evidence was not available at the referee hearing. Simply not subpoenaing someone doesn't mean that that person was not available. Simply because the person was downstate, we could have done a Zoom call, we could have done some other information or other way of getting that information in front of the referee, or you could have asked for an adjournment to make sure that that witness was available to you. So all of the things that you have told me do not fit into these requirements, the laws that I am required to follow. So your objections are just to the results, not to the factual findings of the referee. Your objections are you want to repeat what you told the referee and ask me to make a different decision based on the same type and same quality of information. And that is not what a judicial review is for. The question is there new evidence? There's question is there evidence that was not available to you at the first referee hearing? And I do not find, based on this record, that you have satisfied either of those requirements. So I'm going to deny your request. Mr. Blumberg, would you submit a proposed order?
I will, Judge. Thank you.
Thank you. That's all for today then.
So my question, when does my son have to go to his father? What do I do now?
You send him to his father per the court's order.
The court, or he was supposed to go to his dad for full custody months ago. And he didn't go because of this objection. They told me
Then
not to send him, so.
Mr. Blumberg may file additional requests based on the failure to follow the court's order.
But the court order was he not go to his dad until the objection was over.
So the
That's
objection
what
is now,
a friend of the
the
court
objection
told me,
is now
so.
over. The objection is now over.
Okay, so
Okay.
I need to know when he goes to his dad's, after the weekend, Monday, when? Like, I don't know. It doesn't say anything in the court order. Do we have to file a new court date to see when he goes? Like, I don't know what to do from here.
This says that the order, the referee's order is that the defendant shall have primary physical custody of the minor child. That means the objection is now done. He needs to have that, needs to go to his dad's.
Cool, so he goes to his dad's tonight then.
That is what the order says, primary physical
Okay, so
custody.
when do I get my son back then? Because I haven't even got it in a weekend with my son. His
Ma'am?
dad has had every weekend.
Ma'am, read the court's order. If you have questions
Okay.
about it, you're gonna have to get an attorney because I
All it
cannot
says is
represent
every
you.
other weekend. All it says is every other weekend. So which weekend is mine? Is it this weekend or next weekend?
I cannot represent you. I cannot interpret the order for you. You have to get an attorney, or you can call Mr. Blumberg and negotiate
Okay, because
those
this is supposed to be
issues.
my weekend. This is supposed to be my court ordered weekend. So when does he go to his dad's? On my weekend, or do I not get my weekend?
Ma'am, you just asked the same question again that I previously answered.
Nobody's
I'm not
telling me
gonna
when my
change.
son goes
All right,
or when I
let
get
me
my
ask
time.
Ms.
doesn't-
Ellison, if you could mute her, please. All right, who else do we have anybody in the queue?
You're involved in a dispute with another party such as this, and you just can't seem to work it out. Don't resort to taking the law in your own hands.
We'll hear the litigants